Imagine waking up tomorrow and realizing that everything you built in Canada could disappear overnight. Your job, your studies, your family, even your permanent resident status gone. Sounds extreme. Under the new 2026 deportation laws, this is becoming a real possibility for people who thought they were completely safe. International students, work permit holders, refugees, and yes, even permanent residents are now under closer watch than ever before. One small mistake, one overlooked rule, and deportation could move faster than you can appeal. Stay until the end, because Law Number 7 and Law Number 10 might change everything you thought you knew about staying in Canada. Number 1. Fast-track deportation for visa overstays. The Canadian government is introducing aggressive new measures targeting anyone who overstays their visa or permit. Under the 2026 laws, the grace period that previously allowed individuals some time to correct expired visas has been significantly reduced. This means that students, tourists, and temporary workers who miss their permit deadlines, even by a few days, could now face immediate deportation proceedings. Authorities will no longer provide the lengthy appeal windows that were once standard, making it crucial for everyone to track expiration dates meticulously. Immigration experts warn that this law is designed to streamline enforcement, but it also increases the risk of unintentional violations, putting many who believed they were compliant at risk. For international students, this law is particularly alarming. Many rely on short-term work permits or post-graduation extensions to remain in Canada. Even minor administrative errors, such as missing a renewal deadline by a day, could trigger fast-track removal processes. Temporary workers face a similar risk, as their employer-sponsored visas may expire without clear notice. Legal consultants are advising individuals to maintain a digital and physical record of all immigration documents, including visa approvals, work permits, and study confirmations, to avoid situations where authorities might claim noncompliance. Practical steps are essential to navigate this change. Setting multiple reminders for visa expiration, consulting immigration professionals, and submitting renewal applications months in advance are now not optional but critical. People should also familiarize themselves with the new automated tracking systems that the government is implementing, which monitor visa status in real time. Ignorance of these updates will no longer be considered an acceptable excuse. As a result, everyone residing in Canada, even those with long-term residency or seemingly secure status, must treat visa compliance as a daily responsibility. Failure to act could lead to swift and irreversible consequences, transforming a previously routine immigration process into a high-stakes scenario where one small oversight could jeopardize years of effort, stability, and personal investment. Number 2. Stronger rules for international students. Canada's 2026 deportation laws are placing unprecedented pressure on international students, making compliance with study permits and work regulations more critical than ever. Previously, students who occasionally missed classes or exceeded their off-campus work limits faced minor consequences. Under the new rules, attendance records, work hours, and institutional reporting will be closely monitored by immigration authorities. Colleges and universities now have a legal responsibility to report any discrepancies, meaning that even small oversights can trigger status reviews. Students who once assumed their permit protections were strong may now find themselves vulnerable to fast-track deportation processes. The impact of these changes is far-reaching. Students working part-time while studying must carefully track their weekly hours, as exceeding permitted limits could now lead to immigration penalties. Institutions deemed non-compliant with federal regulations may inadvertently place students at risk, even if the student acted in good faith. Missing documentation, such as proof of enrollment or work authorization, can now be interpreted as non-compliance, giving immigration officers the authority to initiate removal procedures. Experts emphasize that staying well-informed about institutional reporting requirements and maintaining a complete record of academic and work activity is no longer optional. It is a critical survival tool for anyone planning to remain in Canada. Practical strategies to navigate these stricter rules are essential. Students should maintain digital copies of enrollment confirmations, transcripts, and work permits, and verify that their employers are compliant with Canadian work regulations. Consulting immigration advisors before making decisions about employment, program changes, or temporary absences can prevent inadvertent violations. Staying proactive by monitoring government updates on study and work permits is also vital. Ignoring these new regulations could turn a seemingly minor administrative error into a life-altering event, with long-term consequences for career and residency plans. For international students, understanding and implementing these precautions is no longer just recommended. It has become a mandatory part of daily life in Canada, where one misstep can trigger consequences that were previously rare but are now alarmingly common under the 2026 laws. Number 3. Criminal charges equals faster removal. The 2026 deportation laws introduce a dramatic shift in how criminal charges affect residents and immigrants in Canada. Previously, only convictions carried serious immigration consequences, and minor offenses often did not trigger removal. Under the new rules, authorities can now initiate fast-track deportation based solely on criminal charges, even if the individual has not been convicted. This means that permanent residents, temporary workers, and international students could face removal proceedings for minor, non-violent offenses that once would have been overlooked. Legal experts warn that this change significantly increases the risk for anyone with a criminal record or pending charges, making it imperative to act quickly to protect one's immigration status. The scope of these laws is particularly alarming because charges are enough to trigger immigration scrutiny. Individuals previously confident that minor legal issues would not affect their residency may now find themselves under government investigation. For example, being arrested for a traffic-related offense, public altercation, or even minor property damage could now be interpreted as grounds for removal. Immigration authorities are also given the discretion to fast-track hearings, reducing the time individuals have to prepare a defense or appeal. This means that what once might have taken months to resolve can now move within weeks, leaving affected residents little room for error or delay. Preventive and protective measures are crucial under this law. Anyone facing charges should immediately consult an experienced immigration lawyer to understand the potential consequences. Keeping a detailed record of legal proceedings, bail agreements, and correspondence with authorities can provide essential documentation in case of review. Additionally, avoiding situations that could result in legal entanglements becomes even more critical, as minor missteps can escalate into serious immigration risks. Individuals must also stay informed about changes in how specific offenses are classified, since authorities may interpret new rules broadly. Awareness, preparation, and meticulous documentation are no longer optional. They are essential strategies for navigating Canada's increasingly strict approach to criminal charges and deportation under the 2026 legislation, where one small incident could drastically alter a person's future in the country. Number 4. Misrepresentation crackdown. Canada's 2026 deportation laws are introducing a strict misrepresentation crackdown that affects anyone who has submitted immigration applications with errors, omissions, or inconsistencies. Previously, minor mistakes on applications were often overlooked or could be corrected without severe consequences. Under the new regulations, the government is using advanced technology and data sharing systems to detect even small discrepancies, including those from years ago. Individuals who once believed their past applications were secure may now be vulnerable to reinvestigation, and authorities can initiate removal proceedings for misrepresentation, even if the error was unintentional. The impact of this law reaches far beyond first-time applicants. Permanent residents, temporary workers, and international students could all be affected if past forms contain inaccuracies, whether related to work history, study records, or personal details. Even information provided by third parties, such as employers or educational institutions, can now be scrutinized. Authorities are empowered to cross-reference data from multiple sources, including previous applications, social media, and public records, making it harder for anyone to claim ignorance. Legal experts warn that these changes could lead to rapid revocation of status for those who assumed their applications were flawless, creating a sense of urgency for everyone with a complex immigration history. Practical steps to navigate this crackdown are essential. Individuals should review all past applications and seek guidance from licensed immigration consultants or lawyers to identify potential errors before authorities do. If inconsistencies are found, voluntary disclosure can demonstrate good faith and may mitigate penalties. Maintaining documentation of corrections, supporting evidence, and correspondence with immigration authorities is now more critical than ever. Understanding the heightened scrutiny and implementing proactive measures can prevent a minor oversight from triggering fast-track deportation. For residents and temporary visitors alike, awareness and preparation are the keys to safeguarding one's immigration status under these sweeping new rules. With the misrepresentation crackdown, even seemingly harmless mistakes can have life-changing consequences, making careful management of all immigration documents an absolute priority. Number 5. Refugee claim rejections equals quicker removal. The 2026 deportation laws have dramatically altered the landscape for refugee claimants in Canada, introducing a system where failed claims can lead to rapid removal. Previously, rejected applicants often had several months or even years to file appeals, humanitarian applications, or judicial reviews. Under the new rules, the time between claim rejection and deportation has been drastically reduced, leaving many with very little opportunity to challenge decisions or prepare for removal. Refugee claimants from countries now designated as safe are particularly at risk, as authorities assume a lower risk of persecution and are therefore empowered to expedite enforcement actions. This change has far-reaching consequences for both individuals and families. Claimants who had relied on the previous system's leniency may now face immediate consequences after rejection. Even those who have been in Canada for years, building communities, jobs, and networks, are now vulnerable to fast-track deportation. Humanitarian appeals, which once offered a meaningful chance for review, are now subject to stricter timelines and stricter scrutiny, increasing pressure on legal teams to act swiftly. Failure to adhere to the new procedural deadlines can result in permanent removal with little recourse, leaving many applicants with a sense of urgency that previous regulations never demanded. Practical steps for those affected are crucial. Claimants should ensure that all supporting documents for humanitarian and compassionate H&C applications are submitted early, well before a rejection notice arrives. Maintaining detailed personal records, legal correspondence, and evidence of integration into Canadian society can strengthen appeals under these accelerated processes. Seeking immediate assistance from experienced immigration lawyers is now critical to navigating the shortened timelines effectively. Awareness of these changes and proactive preparation can be the difference between being able to stay in Canada or facing rapid removal. Refugee claimants must now treat every interaction with immigration authorities, every piece of documentation, and every legal deadline as crucial, because under the 2026 laws, inaction or delay can trigger consequences that are swift, unforgiving, and potentially life-changing. Number 6. Social assistance and status reviews. Under the 2026 deportation laws, Canada has introduced stricter rules surrounding social assistance used by non-citizens, linking government support directly to immigration status reviews. Previously, temporary residents and some permanent residents could access limited public assistance without triggering immigration scrutiny. Now, receiving benefits can prompt a status review, potentially putting residents at risk of deportation. Authorities are increasingly monitoring who accesses welfare, healthcare subsidies, and housing support, especially among individuals on temporary or conditional visas. This change reflects a broader push to ensure that non-citizens are fully self-sufficient and compliant with immigration regulations. The law's impact is far-reaching because many individuals unintentionally access benefits while believing their status is secure. Temporary workers, international students, and even some permanent residents may be caught off guard if their use of public assistance is flagged. Authorities now have the discretion to question eligibility, request detailed documentation, and initiate removal proceedings. Even benefits obtained legally can become problematic if records are misinterpreted or if the individual's immigration category does not technically allow access. Legal experts emphasize that these reviews can occur without prior warning, meaning individuals may suddenly face high-stakes immigration scrutiny for routine transactions. To navigate these new rules, careful planning and documentation are essential. Anyone receiving government benefits should confirm their eligibility under current immigration regulations and keep detailed records of applications, approvals, and correspondence. Consulting a licensed immigration lawyer or advisor before applying for or continuing benefits can prevent inadvertent violations. Awareness of how social assistance interacts with status reviews is critical, as even minor misunderstandings can trigger significant consequences. Residents should also be prepared to demonstrate financial independence, showing proof of income or employment history when questioned. In a system where immigration status and public support are closely monitored, every interaction with government services can have lasting effects. Being proactive, maintaining transparency, and understanding the legal implications of social assistance use are now essential strategies to safeguard one's residency in Canada under the 2026 deportation laws, where small mistakes could result in irreversible consequences. Number 7. Employer compliance and worker deportations. The 2026 deportation laws in Canada are placing unprecedented responsibility on employers, which directly affects foreign workers. Employers must now strictly comply with labor market impact assessments, LMIs, wage regulations, and work permit rules, as any violations can trigger worker deportations. This means that even if a worker follows all rules, they can be placed at risk if their employer fails to comply with legal requirements. Authorities have been given broad powers to audit employers and review employee documentation, making it crucial for workers to maintain proof of lawful employment and adherence to permit conditions. The law significantly impacts temporary and long-term workers. Workers in sectors like hospitality, construction, and tech may unknowingly face consequences due to employer noncompliance. Even minor infractions, such as underreported hours, incorrect LMIA filing, or unpaid wages, can be interpreted as violations that place employees at risk of removal from Canada. Immigration officers now have the discretion to act swiftly, meaning workers cannot assume they are safe simply because they followed instructions. Legal experts emphasize that this is one of the most alarming changes in 2026 legislation, as it shifts part of the burden of compliance onto employees, who previously relied on employers to handle legal obligations. Practical steps are now critical for safeguarding residency. Workers should keep copies of employment contracts, pay stubs, LMI approvals, and correspondence with employers. Regularly checking that employers comply with immigration and labor regulations can prevent unexpected consequences. Consulting licensed immigration professionals for guidance on employer compliance issues is strongly advised. Workers should also document any disputes or irregularities in the workplace to protect themselves during potential immigration reviews. Awareness and proactive management are essential, as failure to act could transform a previously stable work situation into a high-risk scenario, where even a long-term resident may face deportation due to factors outside their control. For anyone employed in Canada under a work permit, understanding the link between employer compliance and personal immigration status is now a daily necessity, ensuring that one small oversight by an employer does not jeopardize years of work and residency. Number 8. Border Authority powers expanded. The 2026 deportation laws grant Canadian border authorities significantly expanded powers, making entry and re-entry into Canada far more scrutinized for all non-citizens. Previously, permanent residents and temporary visa holders could travel with relatively minimal risk, assuming they carried proper documentation. Under the new rules, border officers are authorized to conduct deeper investigations, request extensive documentation, and detain individuals suspected of noncompliance. Even long-term residents who have lived in Canada for years may now face interrogation or status reviews upon returning from trips abroad, turning routine travel into a high-risk situation. The law particularly affects permanent residents, international students, and temporary workers. Past violations, visa overstays, or administrative errors can be flagged at the border, potentially triggering immediate removal procedures. Officers have broader discretion to interpret documentation, travel history, and compliance records, meaning that seemingly minor or resolved issues could suddenly resurface as grounds for detention or deportation. Travelers are no longer guaranteed smooth entry simply because they possess a valid permanent resident card, work permit, or study permit. Experts warn that failing to carry supporting evidence, travel records, or proof of employment or enrollment could result in lengthy delays or even denial of entry. Practical steps are essential for anyone planning to travel. Travelers should maintain digital and physical copies of all permits, visas, employment letters, enrollment confirmations, and proof of residence. Keeping a detailed record of travel history and prior immigration interactions is also crucial. Consulting with immigration professionals before long trips or after any past compliance issues can help anticipate potential border scrutiny. Understanding that border officers now have enhanced authority to question, detain, and initiate removal underscores the need for vigilance and preparation. In this new landscape, traveling without meticulous documentation can have life-altering consequences, even for those who believe their status was secure, emphasizing that compliance is now a constant responsibility, not a formality, for anyone living, working, or studying in Canada under the 2026 deportation laws. Number 9. Online activity and security screening. Under the 2026 deportation laws, Canadian authorities are now scrutinizing digital footprints and online activity as part of immigration and security screening. Previously, online content was rarely used in immigration decisions, but the new rules allow officials to examine social media posts, public profiles, and online communications for signs of noncompliance, misrepresentation, or potential security risks. This means that applicants, permanent residents, and temporary visa holders can be evaluated based on information they have posted online, even if it seems unrelated to immigration status. One controversial aspect is that posts taken out of context can now trigger status reviews or removal proceedings, creating significant risks for individuals who are unaware of this new level of scrutiny. The law affects a broad range of people: international students, temporary workers, refugees, and permanent residents may find that content previously considered private or insignificant is now used as evidence in immigration decisions. Authorities are particularly focused on political statements, controversial opinions, or associations with certain groups, which could be interpreted as a threat to Canadian security. Even long-standing residents who have not been involved in any legal violations can be questioned if online activity raises concerns under the expanded screening framework. Experts warn that this law introduces a new layer of risk, where one careless post or overlooked online interaction could trigger serious consequences, including fast-track deportation. To protect oneself, proactive measures are now essential. Individuals should audit all public-facing accounts, remove content that could be misinterpreted, and adjust privacy settings across platforms. Maintaining records of online activity and digital communications can also help clarify context if questions arise. Seeking guidance from legal or immigration professionals about online behavior is recommended, especially for those with a complex immigration history or pending applications. Awareness of how digital activity interacts with immigration status has become critical, as one misstep online could have life-changing consequences. For anyone living, studying, or working in Canada, understanding and managing online presence is now a mandatory part of compliance, ensuring that digital footprints do not jeopardize years of effort, residency, or the possibility of staying in the country under the 2026 deportation laws. Number 10. Permanent resident status is not untouchable. The 2026 deportation laws have shattered the assumption that permanent residents, PRs, are fully protected from removal. Previously, permanent residency in Canada was considered a stable status, with revocation reserved for serious violations. Under the new rules, authorities can more easily initiate PR status revocation for a variety of reasons, including minor legal infractions, misrepresentation, or noncompliance with residency obligations. Even those who have lived in Canada for decades without issues are now at risk if they fail to meet new documentation or residency requirements. Experts warn that permanent residency is no longer an absolute safeguard, and PR holders must actively ensure they remain compliant with evolving regulations. The scope of this law affects a wide range of residents. Individuals who assumed they were safe due to long-term residence, stable employment, or community ties may face unexpected scrutiny. Authorities can examine past applications, travel history, employment records, and legal issues when assessing whether PR status should be revoked. Minor infractions, such as brief periods spent outside Canada or small legal issues, can now trigger revocation proceedings. Even those planning to apply for citizenship may be affected if they have not yet completed the required eligibility steps. Legal experts emphasize that proactive monitoring of residency obligations is now critical to prevent sudden status loss. Practical steps are essential to safeguard permanent residency. PR holders should document all absences from Canada, maintain complete legal records, and monitor immigration requirements closely. Applying for citizenship as soon as eligible is a strategic move to strengthen long-term security. But careful attention to compliance in the interim is equally important. Consulting with immigration lawyers can help identify risks and ensure that all obligations are met. Awareness, meticulous documentation, and proactive planning are now central to maintaining PR status. Under the 2026 laws, one cannot rely on past tenure or perceived stability. Instead, compliance and vigilance are mandatory. Permanent residents must recognize that PR status is a privilege, not a guarantee, and any oversight could lead to life-altering consequences, fundamentally changing the future they assumed was secure in Canada. The 2026 deportation laws in Canada are reshaping the lives of millions of residents, workers, students, and refugees. What was once considered secure status, like permanent residency or temporary permits, is now subject to unprecedented scrutiny. From fast-track deportation for visa overstays to the misrepresentation crackdown, the government has expanded its enforcement powers in ways that can impact anyone living in Canada. The laws affect not only newcomers but also long-term residents, emphasizing that compliance and vigilance are no longer optional. They are essential for survival in this evolving legal landscape. For international students, minor administrative errors could trigger removal. For workers, employer violations can jeopardize status. For permanent residents, past assumptions of security no longer hold. Digital activity, social assistance use, and even routine travel are now closely monitored, creating a system where one oversight can have life-changing consequences. Understanding each law and taking proactive steps, like tracking visas, maintaining records, auditing online presence, and consulting legal experts, has never been more critical. These regulations are designed to enforce compliance efficiently, but they also create risks for those who are unprepared. The key takeaway is that knowledge and preparation are your first line of defense. Being informed, organized, and proactive can prevent unexpected consequences and safeguard your future in Canada. These laws are a wake-up call. No one is automatically protected, and everyone must take personal responsibility for their immigration status. Staying updated, seeking expert advice, and acting early are essential strategies to navigate this new, stricter immigration environment successfully. If this video opened your eyes, drop a comment below, sharing which law shocked you the most. Don't forget to watch our previous video for even more crucial updates. We put tons of effort into these videos, so support us and subscribe. It's just one click, and it keeps you informed.